raise awareness exposition on likely effect of failure to comply with United Nations order on President Buhari and Nigeria. This order came based on the resolution of United Nations, Resolution 39/46 of 10th December 1984, based on torture. We will go into it and we will find out what the resolution says. This resolution was drafted during the leadership of military head of state of Nigeria, Lieutenant General Muhammadu Buhari, which came into force during the leadership of General Ibrahim Babangida on 26th June 1987, in accordance with Article 27(1) of United Nations. I wish to employ everyone that is present and all our subscribers and listeners that Massive Freedom and Human Rights Initiative believe by being attentive to this exposition, it will enable you to understand the brewing problems in Nigeria. In effect, Nigerian government is plundering the country, the citizens, into a very big problem because of stubbornness of the president, inability to understand the difference between national or domestic and international law. There is virtually difference between national and international law, and as such, the international law overrides the national laws, provided there is compatibility between the national and international laws. And again, the member state also assented and signed and ratified the international laws that guide every member state. That is a big issue for Nigeria now. Nigeria is plundering the country into a very serious conflict between the United Nations and Nigeria as a state. But before we assess the implications on both President Buhari in particular and Nigeria at large, we shall listen to the relationship between international law and domestic law. We shall listen to the lectures, to the speech of experts as regards to this, so that you'll be able to understand the differences. You will understand the effect and know what international law is when it conflicts or when it has the same motive with international law and failure to comply with the law.
Name just a few of them. To what extent can individuals or corporations rely on international law provisions to defeat the application of national laws? To what extent can you sue the public authorities, the government, for damages when the public authorities have acted in disregard of the international law obligations of the state? Can you rely on a treaty provision in order to claim the invalidity of an administrative decision affecting you, or even the invalidity of an act of parliament? Additionally, questions about the relationship between municipal law and international law also raise constitutional issues about the respective responsibilities of the executive and of the legislature in the making of treaties. And of course, all those questions receive different answers in the different states of the world. So in this course, I can only sketch out the problems and help you to understand them by teaching you how to look at those issues, rather than to teach you how to solve them.
Laws. Again, we will look at justice for serious violation of international law, a note delivered by UN Human Rights Chief, Chair. We will assess Buhari profile also with regards to crimes and obedience to the rule of law.
Either you look at that relationship from the point of view of international law, or you look at it from the point of view of the municipal legal order at stake. Let us start from the point of view of international law. From that perspective, things are quite easy to understand. From the point of view of international law, municipal law, domestic law, is a fact. Remember Article 27 of the Vienna Convention on the Law of Treaties. It is an axiomatic principle of international law that a state cannot rely on the provisions of its own domestic law as justification for its failure to perform its international law obligations. And the reasons for this is that the domestic law is the result of the own and unilateral will of the state concerned, and such will cannot validly defeat the performance of obligations resulting from the common will of various states. The only exception to that principle, you know, is the defect of consent based on Article 46 of the Vienna Convention. Saying that domestic law is a fact from the point of view of international law does not mean that international law would deny the legal nature of domestic law. It simply means that the only question that arises under international law is whether domestic law is in conformity or not with the international obligations of the state. If the domestic law is not in conformity, then the state is responsible for a breach of its international obligations. The domestic law remains valid as a matter of domestic law, and the question is not to know whether it is valid or invalid under international law. The only issue is to know whether it is in fact compatible or not with what international law requires from the state which is the author of the domestic act at stake. In other words, from the point of view of international law, it is somehow a misnomer to say that in case of conflict between a rule of international law and a rule of domestic law, the rule of international law must prevail. And that's a misnomer because actually it is only if there is a real conflict between two norms, two rules, that one can call that one prevails over the other one. But domestic law has no normative status in international law. Domestic law is not a source of international law. Well, true, when a comparative law exercise leads to the discovery of a general principle of law within the meaning of Article 38 of the ICJ statute, domestic law is duly taken into account in the formation of a rule of international law. But this is, of course, something completely different. And when the general principle exists, it exists as a rule of international law despite its domestic comparative law origin. In a case concerning certain German interests in Polish Upper Silesia, the Permanent Court of International Justice famously stated in 1926 that, I quote, "From the standpoint of international law and of the court which is its organ, municipal laws are merely facts which express the will and constitute the activities of states. In the same manner,
in Nigeria, we will look reasons for abduction and rendition of Nnamdi Kanu, the leader of indigenous people of Biafra. Now you can be able to assess from the differences what international law entails when it conflicts or when it is compatible with domestic law. This is one of the areas where most Nigerian politicians, Nigerian lawyers, and those who are in authority fails to understand the leadership and legality of international law, because for many years Nigeria has been ruled by military regime that has no regard to the rule of law, coupled with the number of years the military has ruled as civilians. There are a lot of complicities, violations by Nigerian presidents in the past, from the time of General Olusegun Obasanjo as Nigerian president, then during the time of General Buhari at the moment as Nigerian president. Their decisions conflict with international laws. They do not understand the implications of their failures. The only good thing is many Nigerians do not take their cases beyond the domestic level. Sorry, they do not do so. As a result, they have allowed the rule of law to decay. Nigerian judges comply and listen to the leaders, political leaders, and not what the laws of the land says. The president, the governors dictate in most cases what the judges at the law court says, which means there is no separation of powers in Nigerian legal system, where the president or the governors or the influential politicians dictates what the judges of Nigeria rule. Now we will continue as we have earlier stated. We will listen to the Secretary General or the representative of Secretary General and the United Nations Human Rights Chief, Michelle herself, speak at a particular occasion. Now let us see what she has to say.
This council's creation of UNITAD to enhance criminal accountability for crimes of Daesh, ISIL, Daesh accompanies the General Assembly and Human Rights Council establishing independent investigative mechanism to do likewise Syria and Myanmar. And through further action of the Human Rights Council, there are currently no fewer than 12 specific human rights mechanisms active addressing various forms of accountability. Today, I wish to highlight 3 ways in which my office is contributing to efforts to strengthen accountability and justice for serious violations of international law. First, the UN Human Rights Council has stepped up its response to serious human rights violations that may also amount to international crimes. This includes creating mechanisms with mandates to establish facts and in circumstances of violations, to collect, consolidate, preserve, and analyze information and evidence, to identify those responsible, and to make recommendations towards future accountability. My office is continually strengthening its support to such mandates, which we see as key contributors to justice and rule of law, including through accelerating and streamlining the operationalization of mandates. The work of these mechanisms have been used by international courts addressing both state and individual criminal responsibility, as well as national prosecutors and judges pursuing international crimes, including under principles of universal and extraterritorial jurisdiction. The conviction in Germany of Syrian Colonel Anwar Aslan for overseeing torture at a Syrian detention center nearly a decade ago adds to the growing number of jurisdictions working with diverse partners, including vital society actors, towards delivering accountability for international crimes. My office is committed to providing the support necessary for each mandate entrusted to us to operate in line with the highest standards of human rights fact-finding, including through the use of modern methodological and investigative techniques. Efforts have a focus on the gathering and preservation of information with a view to increasing the likelihood that it can be used in diverse legal proceedings, on strengthening chain of custody, on explaining and procuring fully informed consent of victims, witnesses, and other information providers in accountability context.
Thank you very much. You can be able to hear the operational basis and how the international community takes seriously the complaints, takes seriously the failures of leadership of any nation. There is no doubt for those in Nigeria, Nigerian politicians, Nigerian leaders, to take into account that their activities can be reported, and there has been an enhanced methodology to accelerate quick information and assess every report. And it is in this very regard that relevant treaties providing those jurisdictions for the basis of accountability, including the Rome Statute of International Criminal Court, deserves a universal adherence. That is where Nigeria has a problem. That is where Nigeria has a problem. Because they ratified most of those treaties, most of those covenants. And when it comes to compliance, Nigeria refuses to recognize the laws they assented to. But they failed also to recognize that the jurisdiction of International Court of Justice is for the entire international community who are part of the treaties, who signed for the treaties. And that is where the report of Nnamdi Kanu and his legal team is generating heat in Nigeria, because Nigeria signed most of those covenants that prohibits torture in any ramification. And this makes this order and the assurance that the rule of law is complied with is what is threatening the accountability and justice for serious violation of international laws. Buhari is in the hand of international law. Nigeria is in the hand of international community. Failures to comply is what justifies the international community to come in. They step in where there are torture, which Nigeria has carried out, probably because Buhari was not touched in 1984 when he began this international kidnapping. Therefore, he believed that this should continue. This is a different century. After all, those who were complicit in similar act he performed in Western world gave their life for it. Once they were implicated, they faced the national courts or international court. But in Nigeria, this did not apply. And because the authorities in Nigeria do not have recognizance of the international treaties, the international laws, but they are happy to jump on the table of United Nations to address the World Assembly when they are not, in fact, prepared to obey the covenants and the treaties they signed for. That is the problem that put Nigeria into the hand of United Nations. Unfortunately for them, the human rights chief, or chief, as case may be, is not prepared to lose ground of his administration, to give up, perhaps, like others at the national level. He has responsibility to ensure that rule of law is obeyed. We will continue as this lecture is indeed a very important lecture, and we will continue looking at the implications. Now, having established from a different speaker the difference between the national and international law, and having heard from the human rights chief herself, where the reports of the covenant of torture was placed for consideration by the experts themselves who undertook these reports. They are not black people. They are not prepared to overturn issues when there is evidence that such failures and the crimes are established. The best for Nigeria is to comply. Its failure may lead to sanctions, indictment that may place the president in the hand of international police, whereby he may be declared wanted and arrested and moved to Hague. From what the United Nations Human Rights Chief is addressing, there is no doubt that they are serious. It is time that issues that can be resolved amicably be resolved. We will go in detail later, not now, on the effect of this torture. Because when you look at the system, the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, United Nations released demand to Nigeria on Nnamdi Kanu based on this Resolution 39/46 of 1984 is not a joke. The Committee Against Torture has made their recommendations, they've carried out their reports, they've carried out and examined the complaint and come out to give a categorical statement that should be obeyed. This is not military era where, or nor the time of conflicting era of socialist government and the Western world. The time is over. This is the time compliance, obedience, as it may be. It's not a political issue here, but the obedience to the rule of law. Because Buhari himself is having crimes in his hand if it is triggered, because he has a crime against the Nigerian state for plotting coup and overthrowing a constituted and democratic government of Nigeria elected by the majority of the people. This goes to sedition, insurrection, kidnapping, terrorism, and murder. All these have been established, and people have, for some time, lodged complaints that have been lying with the United Nations. And in the present period, there has been the repetition of the same kidnapping, terrorism, and murder in Nigeria under his own leadership. So this is the time he has to change his mind. He should not allow himself to be controlled by Fulani groups. May Allah asking him to ignore the United Nations order to release Nnamdi. He has to realize that May Allah will not prevent international police from arresting him. May Allah cannot stop international court from prosecuting him. May Allah has no role at all when it comes to international community. Their advice to have their own will be carried out cannot save the actions when it starts. There are times when issues should be resolved, irrespective of the consequences, to avert the adverse effect in future. You look at the president, he has addressed the United Nations more than 2 or 3 times since he assumed Nigerian leadership as president of Nigeria. He has been attending international occasions. He should realize what is at stake. Then you should ask, what will be the incoming president face in a system whereby the United Nations warning to Buhari under the resolution 39/46 of 1984 fails. When he fails to comply, What will be the advice of the presidential candidates to Buhari? Will they meet to speak with him? Will the National Assembly advise him? Will the state governors advise him? His problem is also will attract the complaints against some state governors, especially those from the southeast, because they have done much harm under pretext, and many people have been killed. Many youth have been killed, properties burnt. The military officers, they represent authority. In the next lecture, we will bring out facts for those in authority to realize that they represent a nation, they represent a state. Their activities are accountable, and the Nigerian president maybe do not understand his responsibility as a president and as the man who guides or who guards the laws in Nigeria. Probably Nigeria is filled with a lot of problems. They are talking of cow roots from north to south. They are talking of Boko Haram. They are talking of ISWAP. They are talking of corruption that may have drifted their thinkings. But most importantly, the presidential candidates had to sit down with the National Assembly and Buhari to resolve this issue before it escalates. Because if Buhari fails to comply, the next incoming president may bear the consequences. Nnamdi Kanu legal team is not giving up. They have international legal team and national legal team who are working seriously to ensure that the inhumanity, the violation of rights of Nnamdi Kanu with the United Nations will be left unpunished. They have to realize this. There is no big manism in law when it comes to international community. You may show your power. You may be big man in Nigeria. You may override all legal issues in Nigeria. But when your hand is placed in an international court, your problem begins. Check how many heads of state that have been sent there or have had their issue there that came back happily. So we are in this particular exposition trying to alert the Nigerian government and its allies, especially the Meiti Allah, who is in control of the president's decision to rethink. Time is going. The rule of law has no special influential candidate. When you commit crime, the Western allies will withdraw their support for you because they will ask you to go and face the crime. They may support you at the initial stage, but when the reality comes, they have no option. Remember President Olusegun Obasanjo when Taylor was in his state house. When pressure came for his release, he has no option to release him to avoid putting Nigeria into danger. This is because Buhari kidnapped a citizen of the world without extradition, tortured him, which was in the open, and continued to abuse the legal process in the criminal case. Perhaps he wants to have the same solitary confinement in a foreign land. In this situation, at this very point, we will end this exposition. The next, we will come back to give details of how and what will happen. From the law, we are going to give more lectures, and more speakers will speak on the issues that Nigerians need to know. Perhaps they have never had the opportunity to have or to listen to, because Nigerians are preoccupied with economic problems, social problems, lack of employment, that do not give them chance to organize things by themselves and understand what the legal process is all about. In the next one, we will look at the legal failures of President Buhari. We will look at the role of United Nations on the issues of torture. We have just made the preliminary and what they intend to do in the next lectures, because there are rules that accompany any failure and what those rules are. We will continue this lecture to ensure that the people of Nigeria understand the implications of torturing the citizens, abducting the citizens, murdering the citizens. Nigeria is not at war. We will go into that because many people have been killed with disregard to the law, with disregard to international treaties signed against such treatments. The governors of Southeast, you have to take note and be able to listen, and listen effectively in the next lectures, because it will touch your activities. Nigeria is not at war. Any crime committed by any person, the right thing to do is to use the law enforcement agent to arrest him and take him to the court of law, and not to kill him, not to bring military, not to bring security agents, not to kill any of them, because that is not what the rule says. Nigeria is not at war. Thank you very much for listening. We will see what happens in the next lectures. Please, do not fail to share this exposition to your loved ones. Give us a thumb. Press the notification bell. It will come to you. We will continue. We will see what happens in the next few weeks and months as we continue in this very exposition. Do not gossip of what will happen, but read and listen to the exposition. You can make your own further report or research, because this is only to ensure that people start reading beyond the national level. You go in to know why your president spends money traveling from the nation to New York, to Vienna, to Geneva to attend international meetings. And when you hear that treaties are signed, you go and find out what those treaties are. And for those in the legal profession, especially the judges and the Minister of Justice, it is your duty with your group to be reviewing the international rules, international treaties, to enable you to advise the president of the country so that he will not be complicit with the rule of law the nation signed into with under free mind with other countries. Thank you very much, and God bless you all.